Hello everyone. So today we are going to discuss the scanner for the chapter Management and Administration from section 88 to 122. Now you already are aware that whatever questions are given in my scanner, that is, it's the previous year question papers and the RTP and the mock test which have been conducted by the institute. So though practical questions we are going to discuss in details, when it comes to theory questions I am not going into the details because it's theory, it's very easy to understand, there is nothing actually to understand in that. And the revision notes for the same have been uploaded, so you can check or go through that to understand it. So moving on to the questions. The first question, annual general meeting need to be called by giving 21 clear days notice. However, it can be called on a shorter notice if members entitled to vote in that meeting give their consent. How many members? 95%. So what's the answer? 95% of the members entitled. Super Tech Computers Private Limited has 120 members. It sends notice to all of them. 20 members did not attend the meeting. So how many attended? 100. Out of the remaining 100 members, 20 members abstained from voting. So 20 did not vote. So how many voted? 80. How many members should vote in favor of the resolution if it is to be passed by a special resolution? That means 75% minimum. What is 75% of 80? It's 60. So minimum 60 votes in favor, then we can say that the resolution has been passed. So it is A. So the answer is D and A. The next question, all the members of Taxila Traders Limited have valid voting rights. Due to some urgency, its directors are desirous of convening the annual general meeting at a shorter notice than statutorily required. Is it possible for them to do so? We had just discussed that in case of shorter notice, it's valid if it is agreed by 95% of the members. 40 members are there. What will be 90% of 40 members? At least 38 members should agree. So the notice, the meeting would be valid if called at a shorter notice if it is agreed by 38 members. So the answer is C. The next question, in the current financial year, Zoom Traders Limited, a non-listed company, has 556 members, increased from 451 members, which it had in the immediate previous financial year. For the forthcoming annual general meeting, advise the company whether it is required to provide to its members the facility to exercise their right to vote at the AGM by electronic means. Now, as the rules companies management and administration rule says that to give voting facility, voting by electronic means, 1000 members, the company should have at least 1000 members or the company should be listed. Now, if we look at this question, it's a non-listed company. So, if it's a non-listed company, it requires to provide voting facility only if it has 1000 members. In this case, does it have 1000 members? No. So, is it required? No. The company is not required to provide to its members the facility to exercise their right to vote at the forthcoming AGM by electronic mode since its members are less than 1000. So, the answer is B. Here the answer given is incorrect. It would be B. The answer would be B. Moving on to the next question, Messrs. Philip Limited maintains its register of members at its registered office in Mumbai. A group of members residing in Kolkata want to keep the register of members at Kolkata. A company can keep its register at, the register should be kept at where? Registered office. The company can keep its register at any other place where at least 1/10 of its members reside. So, if 1/10 of the members reside in Kolkata, it can keep its book in Kolkata. So, it should be kept at the registered office, may be kept at any other place in India if approved by a special resolution and 1/10 of the total number of members entered in the register reside in that place. Then, further the question says, does Mr. Rich, holding 400 shares of total worth 4000 only, has the right to inspect the register of members? The register of members can be inspected by any shareholder or director of the company at any time without giving any fee. So, that a member, debenture holder and other security holder or beneficial holders shall have a right to inspect the register during the business hours without the payment of any fee. So, can he? Yes. Doesn't make a difference how many shares you are holding. Even if you are holding a very minimum amount of shares, still you have a right to inspect. Due to heavy rains and floods, Chennai Handloom Limited was unable to convene annual general meeting up to 30th September 2017. The company has not filed the annual financial statement or the annual return, as the directors of the company are of the view that since the annual general meeting did not take place, the period of 60 days for filing of annual return is not applicable, and thus there is no contravention of section 92. Section 92 says that it should be submitted, it should be filed within 60 days of the AGM, right? It further says, and if no AGM was held within 60 days from the day it should have been held. So, if we consider this point, is the justification of the directors valid? No. The last day by which the meeting should have been held, within 60 days we have to file. See, if no annual general meeting is held in any year, it shall be filed within 60 days from the date on which the annual general meeting should have been held. So, is the director justified in saying no? So, the contention of the directors is not correct. Examine the validity of the following with reference to the relevant provisions of the Companies Act 2013. Mr. Bhim is holding 500 shares of XYZ Limited of total worth of 5,000 only. Advise whether he has a right to inspect the register of members. We have already discussed. So, he will have a right to inspect during the business hours without the payment of any fee. The next question, as per the provisions of the Companies Act 2013, every company is required to file with the Registrar of Companies the annual return as prescribed in section 92 in form MGT 7. Explain the particulars required to be contained in it. What do we specify? The registered address, the shares and debentures of the company, the members and debenture holders along with changes in it, how many meetings the company has held, what are the penalties that the company had to face, then what remuneration it is paying to its directors and key managers, then if any other any matters which relates to the compliance of any act, and any other matter as may be specified. Messrs. Techno Limited maintains its register of members. We have already discussed this. Here the question is a little different. What is the difference? Here they are saying Mr. Ranjit, director but not a shareholder of the company. Can he inspect? What the act says is that the right to inspect during the business hours, the member, debenture holder and other security holder or beneficial holders shall have a right to inspect the register during the business hours without the payment of any fees. Any other person may also have the right to inspect such register on the payment of the fees. So, in this case, he is not a security holder, he is not a member, he is not a debenture holder. Can he inspect? Yes, but only if he pays the fees. The next question, Nimrana Infotech Limited was incorporated on 1/4/2017. No general meeting of the company has been held so far. Explain the provisions of the Companies Act 2013 regarding the time limit for holding the first AGM of the company and the power of the registrar to grant extension. The first AGM should be held within 9 months from the end of the end of financial year. Here the company was incorporated on 1/4/2017. So the financial year ends on 2018. 9 months means what? 31st December 2018 the meeting should have been held. Registrar to grant extension of time. Can the registrar grant extension? Yes. If the company is unable to hold the meeting, the registrar can grant an extension of not more than 3 months. However, for first meeting, no extension can be granted. So, in this case, the registrar cannot grant any extension. So, in the given case, the company and his will be liable. Okay, what happens if the company fails to hold the meeting within the time specified? They are liable under section 99. What does section 99 say? That every company and every officer of the company who is in default shall be liable to a fine which may extend to 1 lakh, and in case of continuing default, further fine of 5,000 for every day during which the default continues. Here, the company should have held the meeting by this day. It fails to hold it, so it will be punishable under section 99. However, in this case, no extension shall be granted as it is the first meeting. So, registrar can grant, but as this is the first meeting, no extension can be granted. Rizwan Limited, a listed company, is in the business of garment manufacturing and has its registered office at 123 N Tower, Commercial Beta Complex, Bhiwadi, Rajasthan. The company has called its 6th annual general meeting at 3 p.m. on 22nd August 2019 at Ansal Plaza, Bhiwandi. Some of the members of the company have opposed the calling of the meeting at Ansal Plaza. The company has approached you to advise them in this regard. Suppose Rizwan Limited is an unlisted company and wants to call their 6th AGM at Jaipur. Will your answer differ? First of all, what does section 96 talk about the place of meeting? Meeting should be held at the registered office, or it should be held within the same city, town or village in which the registered office is situated, correct? Okay. So in this case, it is not at the registered office, but it is within the same city or town or village. So can the members oppose to the calling? No, it's absolutely valid. What would be your answer if they decide, if it's an unlisted company and they decide to call their meeting at Jaipur, that is not within the city? In case of an unlisted company, it can be called, in case of an unlisted company, it can be called anywhere in India. So if it is in India, it's okay. But if they decide to call somewhere outside India, that's not valid. It can be called anywhere in India if prior consent of how many members? Please understand, all. In shorter notice, it was 95%. But here it is not 95%. It is consent of all the members, either in writing or electronic mode is taken. I have said prior consent. So I call and then take the consent, not valid. First we have to take the consent of all the members. So even if a single person refuses, not valid. So can it call at any other place? Yes, if it has got the prior consent. So in the above case, thus the company is right in calling the annual general meeting at Ansal Plaza. If the company is an unlisted company, it may be held at any place in India if consent of all the members is taken. Okay. Examine the validity of the following with reference to the relevant provisions of the Companies Act. The Board of Directors of Shrey Limited called an extraordinary general meeting upon the requisition of members. However, the meeting was adjourned on the ground that the quorum was not present at the meeting. See, the general rule is that if the quorum is not present, the meeting stands adjourned to the next week, same day, same time. If at the adjourned meeting also quorum is not present, the members present shall constitute the quorum. But when the meeting is called upon the requisition of the members, and the quorum is not present, see, the whole point is you are calling the meeting and you are only not present, the meeting shall be cancelled. It's not adjourned, the meeting shall be cancelled. So the meeting shall stand cancelled. Therefore, the meeting shall stand, and the decision taken by the Board of Directors to adjourn it is not proper. I hope it's clear. The next question, Primal Limited is a company incorporated in India. It owns two subsidiaries, Privi Limited, in which it holds 75% shares, and Malvi Limited, a wholly owned subsidiary. Both the subsidiaries are incorporated outside India. The Board of Directors of Primal Limited intends to call an EGM of Primal Limited on urgent basis. Advise the Board of Directors on the following. Can the EGM be held in India? Can the EGM be held in Netherlands? Now, as far as the EGM is concerned, what the law says is EGM can be held anywhere in India. For a company, if it is a wholly owned subsidiary of a company incorporated outside India, if a company is a wholly owned subsidiary of a company incorporated outside India, it can be held even outside India. In this case, Primal Limited wants to call the meeting. Primal Limited is a company which is incorporated where? In India. So can it hold in India? Anywhere in India? Yes. Can it hold in Netherlands? No. So the Board of Directors can call the EGM in India, but it cannot call the EGM of Primal outside India, as it is incorporated in India. To remove the MD, 40% of the members of Tiger Farms Limited submitted requisition for holding an extraordinary general meeting. The company failed to call the said meeting, and hence the requisitionist held the meeting. Since the managing director did not allow the holding of the meeting at the registered office of the company, the said meeting was held at some other place and a resolution for removal of the MD was passed. Examine the validity of the said meeting and the resolution passed therein under the provisions of the Companies Act 2013. This was a question we used to do in the class, and my students were like, we could feel you talking to us when we were reading this question. Anyway, coming to the question, when if we talk about EGM, it can be held anywhere in India, but when the meeting is called, when an EGM is called by the requisitionist, it must be held at the registered office or any place within the same city, town or village in which the registered office is situated. In this case, because the registered office was not made available, they held the meeting elsewhere. Elsewhere obviously means within the same city, town or village. So, is the meeting valid? Yes. Is the resolution valid? Yes. So, when the meeting is called by the requisitionist, the meeting must be held at the registered office or within the same city, town or village in which the registered office is situated. In fact, in the case of R. Chettiar versus M. Chettiar, this was the details of the case. It was held that the meeting can be held anywhere else. Since all the above desired provisions are duly compiled with, the meeting and the resolution passed shall be valid. Zorab Limited served a notice of the general meeting upon its members. The notice stated that a resolution to increase the share capital of the company would be considered at such meeting. A shareholder complained that the amount of proposed increase was not specified in the notice. Is the notice valid? Section 102 says that in case of a special business, a notice, along with the notice, a statement has to be given, and this statement must give all the information and facts that may enable a member to understand the meaning, scope and implication of the items of the business and to take decision. In this case, they had told that the company had given a notice to increase the share capital, but how much, why, nothing was given. So, can we say the notice is not valid? Yes. So, thus the objection of the shareholder is valid and the notice is therefore not a valid notice under section 102. Coming to the next question, Prem, a director in a public company, gave in writing to the company that the notice for any general meeting and the board of directors meeting be sent to him at the address in India only by registered mail. Only by registered mail, and for which he paid sufficient money. The company sent to notice to him of such meetings by ordinary mail and under certificate of posting. Prem did not receive the said notices and could not attend the meetings where the proceedings thereof on the ground of improper notice. Decide in the light of the provisions of the Companies Act. Now, section 20 talks about notice. It says that any notice which is sent by under the certificate of posting is valid. But it also says that if a person has specified a particular mode for receipt of notice and has paid money to the company to defray such expenses, that is, if the member has specified that please send me the notice in this mode and that particular member has paid the company money to send the notice in that mode, notice must be in the specified mode. And if it is not in the specified mode, it is not a valid notice. In this case, the contention of Prem shall be tenable for the reason that the notice was not properly served and meeting held by the company shall be invalid. Notice is a requisite. So, if the notice is not proper, it is not a valid meeting. Would your answer be still the same in case Prem was outside India? When he was outside India, the company is not liable to send him at the address outside India, but the company is liable to send him at the registered address in India by the registered mail. So, yes, still if the company has not sent in this mode, he can hold the company liable. Glowing Products Limited, hold liable for not sending him at the registered address in India, not outside India. Glowing Products Limited wishes to sell one of its line of business and decides to call an extraordinary general meeting and to pass a resolution. State the material facts to be set out in the statement to be annexed to the notice, to the notice of the EGM on this special business to be transacted at the meeting. It is again a very direct question. It has to tell the nature of concern. If the directors or key managerial persons or their relatives are interested in the contract, they have to give the details of it. Second, any further facts or informations which will help them to what? To understand and make a decision about the scope and the whole concept of the contract. If my company is making a contract which affects another company And if the directors or key managerial personals or their relatives of my company hold 2% or more of the shares of that other company, that disclosure also has to be made. The date of approval of financial statement by the Board of Directors of KMP Limited is 17 July 2016 and the date of notice of annual general meeting is 25th August 2016. Accountant of KMP Limited has advised that the time gap between the date of approval of financial statement by the Board of Directors and the date of notice of AGM should be 45 days. The directors have approached you to advise them regarding the same in view of the provisions of the Companies Act. Now the thing is that the Companies Act gives us the time for the notice of a general meeting, but it does not give us, no time has been given for the date of approval and the date of the notice of the annual general meeting. So the whole point is that we don't have any time limit for this, but yes, if the notice is sent for the meeting, it should be at least 21 clear days before the meeting. Madurai Limited issued a notice for holding its annual general meeting on the 7th of November. The notice was posted to the members on the 16th of October. It was posted. Posted ka matlab we need another 48 hours. On 16th October it was posted. So it is 21 clear days notice. That means we exclude the day of posting and the day of the meeting. So how many days in November? 6 days in November we are getting, and 17, 18, 19, 20, 6 days in November we are getting, and in October we are getting 16, 17, 18, 19, 24 days here, plus how many days? 11 days, right? So we are getting all total of 21 days, clear days. But then 48 hours has to be given as per section 20. When it is sent by post, it is deemed to have been served 48 hours after posting. So it should be 21 days plus 48 hours. So it is shorter by 2 days, yes, or 48 hours. So the notice is not valid as it was not a 21 clear days notice. The notice is short by 2 days. The Companies Act does not provide anything specific regarding the, let's read that question importantly. Can the delay in giving the notice be condoned? Now to understand this, it's important for us to understand what does the word condone mean. Condone means to overlook. Overlook something which is not as per the legal requirements. Can we overlook? No. With the consent of the shareholders, a meeting can be called by a shorter notice, but we cannot overlook that shorter notice. So, the Companies Act does not provide anything specific regarding the condonation of delay. The next question, KMN Limited scheduled its annual general meeting to be held on 11th March 2018 at 11 a.m. The company has 900 members. 900 members means quorum shall be 5 members personally present. On 11th March, the following persons were present by 11:30. P1, P2, P3 shareholders will count them. P4 representing will count him. P5 representing will count him. Proxies not counted. So how many are present? 5. Is the quorum present? Yes. What will be your answer if P4 representing ABC Limited reached the meeting after 11:30? See, we wait for half an hour. We wait for half an hour for the quorum. If by half an hour, the meeting was called at 11, half an hour is 11:30. If by 11:30, quorum is not present, the meeting shall stand adjourned. If by half an hour, that is 11:30, quorum is not present, the meeting shall stand adjourned to the next week, same day, same time. What happens if there is no quorum in the adjourned meeting? If at the adjourned meeting also quorum is not present, the members present shall form the quorum. So coming back again to our answer, thus the quorum is present. If P4 arrives after 11:30, the quorum is not present, as the quorum should be present within half an hour, thus the meeting shall stand adjourned. If the meeting is adjourned for lack of quorum and at the adjourned meeting also quorum is not present, the members present shall constitute the quorum. Correct? Moving on to the next question, examine the following with reference to the provisions of the Companies Act 2013. The Articles of Association of DJA Limited require the personal presence of 7 members to constitute quorum of the general meeting. The company has 965 members, so it's not against the Act because Act says 5. As on the date of the meeting, the following persons were present in the EGM. A, the representative of Governor of UP. D, representing XY Limited, Z Limited. He shall be counted as a member personally present for each such body corporate. Proxies. Determine whether the quorum is present or not. Do you think the quorum is present? No. Thus, we can conclude that the quorum is not present. Why? Because only how many members are present? Only 3 members are present. The next question, explain the provisions of the Companies Act relating to quorum for general meeting of a public company having total 30 members, of which 2 members are body corporate and 1 member is the President of India. Whether the representatives appointed by the body corporate and President of India to participate in the general meeting shall be counted for quorum. Yes. 30 members, so quorum shall be 5 members personally present. Body corporates and President of India, they shall be counted, their representative shall be counted as a member personally present. The next one, examine the following with the reference of the provisions of the Companies Act 2013. Siraj, a shareholder, gives a notice for inspecting proxies 5 days before the meeting is scheduled and approaches the company 2 days before the scheduled meeting for inspecting the same. What is the legal position relating to his actions? Can a member inspect the proxy form? Yes. But if he wants to inspect a proxy form, he has to give a 3 days notice. Inspection can be done 24 hours before the meeting till the conclusion of the meeting. In this case, 5 days notice, okay, but he wants to inspect 2 days before the meeting. Can he do that? No. So, can undertake the inspection only during an above mentioned period and not 2 days prior to the meeting. A general meeting was scheduled to be held on 15th April 2017 at 3 p.m. As per the notice of the members who are unable to attend a meeting in person can appoint a proxy, and the proxy form duly filled should be sent to the company as to reach at least 48 hours before the meeting. Mr. X, a member of the company, appoints Mr. Y as his proxy, and the proxy form dated 10/4/2017 was deposited by Mr. Y with the company at its registered office on 11/4/2017. Similarly, another member, Mr. W, who also gives 2 separate proxies to 2 individuals, named Mr. M and N. In the case of Mr. M, the proxy dated 12 was deposited with the company on the same day, and the proxy form in favor of N was deposited on 14. All proxies Y, M and N were present at the meeting. In case of multiple, first of all, proxy form has to be submitted. How many days? 48 hours before the meeting. Okay. Mr. X appointed a proxy. The date of the meeting was 15th April. Okay, the date of the meeting is 15th April. Now, Mr. X, a member of the company, appoints Mr. Y as his proxy and deposits the same on 11. So, is it 28 hours? Yes. 48 hours? Yes. So, Mr. Y's proxy is valid. Now, another member, Mr. W, also gives 2 separate proxies. Now, Mr. W has given 2 proxies. One in favor of M, one in favor of N. The one in favor of M was given on 12/4. The one in favor of N was given on 14/4. Now, remember, in case of multiple proxy, there is multiple proxy. The proxy later in time, that means the second one, when I give a second proxy, the first one is automatically revoked. The proxy later in time within the statutory limit shall be valid. Now, if I take this, the one later in time is N. But we already know that proxy form should be 48 hours before the meeting. It is not 48 hours before the meeting. Had it been 48 hours before the meeting, N's proxy would have been valid. But since it's not 48 hours before the meeting, M's proxy is valid. So, who has a right to attend the meeting? Y and M. So, on X and M will, the Y has a right to attend on behalf of X, and M shall have a right to attend on behalf of W. What do you mean by proxy? Explain the provisions relating to appointment. Not going into this, it's a very, very simple question. In an annual general meeting of Vrinda Limited having share capital, 80 members present in person or by proxy holding more than 1/10 of the total voting power demanded for a poll. The chairman of the meeting rejected the request on the ground that only members present. No. The Act clearly says that members in person or proxy. So, is the chairman's decision justified? No. In an annual general meeting, during the process of poll, the member who earlier demanded for poll wants to withdraw it. The chairman of the meeting rejected the request on the ground that once poll started, it cannot be withdrawn. Now, section 109 clearly states that the poll can be withdrawn at any time. So, on the ground that both the contentions are not justified. So, coming to the answer, the chairman cannot reject the demand for the poll, cannot reject the request of the member to withdraw the poll. Mr. Pink held 100 partly shares, paid up shares of Red Limited. The company asked him to pay the final call on the shares. Due to some unavoidable circumstances, he was unable to pay the amount of call money to the company. At the general meeting of the shareholders, the chairman disallowed him to cast his vote on the ground that the articles do not permit a shareholder to vote if he has not paid the calls. Restriction on voting rights as given under section 106 can be done if the articles authorize. Restrictions on voting can be done only if the articles authorize, and only on two grounds: non-payment of calls or company exercises a lien on shares. On no other grounds can we restrict the voting. Can we restrict him here? Yes. Chairman is well within his rights to refuse him the right to vote at the meeting, and Mr. Pink's contention is not valid. X, a member of LKM Limited, is holding 250 shares which are partly paid. The company held it where voting rights was denied to X, claiming that he has not paid the calls on the shares held by him. Examine the validity of the company's denial to X with reference to the relevant provisions of the Companies Act, assuming that the articles of the company do not restrict the voting rights. I already told you the restriction can be only if the articles from exercise is not valid. Why? Because the articles have to specify. If a member of a listed company who has casted his vote through electronic voting can attend general meeting of the company and change his vote subsequently, when the voting is done through electronic mode, can he attend the general meeting? Yes. Can he change his vote subsequently? No. Once he has cast his vote, the vote is logged. Can he appoint a proxy? No. So, he can attend the meeting, but he cannot appoint the proxy or change his vote, but cannot change his vote and is not permitted to appoint a proxy. XYZ Energy Limited set up with the object of setting up a windmill project, raised money from public through prospectus, and still has unutilized money out of the money raised. XYZ Energy Limited proposes to change its object, and for this purpose consent of shareholders has to be obtained by passing a special resolution by postal ballot. Explain the procedure. We are not going into this. It is the procedure of postal ballot. Members of ZA Limited holding less than 1% of the total voting power want the company to give a special notice to move a resolution for the appointment of an auditor other than retiring auditor. Explain whether the members have complied with the relevant provisions of the Act. Well, to call a meeting by a notice requiring special notice, at least it should be at least 1% or shares on which not more than 5 lakh has been paid. So since it is not more, it's less than 1%, then it's not valid. So notice of the intention to move such resolution is not valid, as there is non-compliance of requirement of section 115. Benson Limited issued a notice with the agenda for 9 business to be transacted at the annual general meeting. 2 business were regarding the appointment of Mr. Sahu and Mr. Pranav as directors. For all the together, to save time, can they do so? See, as far as the Act is concerned, nothing is given that you cannot club resolutions. So, you can club 2 or more business together and pass a single resolution. However, in case of appointment of directors, you cannot pass a single resolution. Why? See, it's very simple. Let's say X and Y are supposed to be appointed. And if you say one single resolution to appoint both, I want X but I don't want Y. So to appoint X, I have to appoint Y. And to reject Y, I have to reject X also. So this cannot be done. However, if I have already passed a resolution that we will appoint both of them by a single resolution and everyone has given the consent, then this can be done. Otherwise, this cannot be done. Rest can be clubbed. So, in the instant, all the 9 business cannot be moved together, as 2 business were regarding appointment of Mr. Sahu and Mr. Pranav as directors. Beside these 2 resolutions, other 7 resolutions could be moved together if the members unanimously agree. Give the points of distinction between ordinary and special resolution. It's a very simple question. You just have to read. Again, special notice. Very simple, seedha question. At the general meeting of XYZ Limited, a matter was to be passed by a special resolution. Out of 40 members present, 20 voted in favor, 5 voted against, and 5 votes were not found invalid. The remaining 10 members abstained. See, simple. Who have not voted, we don't take them. What is favor? What is against? 5. The votes in favor should be at least 3 times the votes against. What is 3 times the votes against? 15. More than that? Yes. Special resolution is passed? Yes. Thus, the decision of the chairman is in order. In the general meeting of Amit Limited, the chairman directed to exclude certain matters detrimental to the interest of the company from the minutes. Manoj, a shareholder, contended that the minutes must contain fair and correct summary of the proceedings. Decide whether the contention of Manoj is tenable. See, 3 cases. 3 cases we can reject a matter to be included. It is at the discretion of the chairman. If the chairman feels that a particular matter was immaterial, or a particular matter was irrelevant, or it was detrimental to the interest of the company. If the chairman is of the opinion that it is reasonably regarded to be defamatory of a person, or if it is immaterial or detrimental to the interest of the company, it can exclude those matters. So it is at the discretion of the chairman. So is the contention of Manoj valid? No, it's not. Zenab Limited held its annual general meeting on September 15. The meeting was presided over by Mr. Venkat, the chairman of the company's board of directors. On Mr. Venkat, without signing the minutes of the meeting, left India to look after his father who fell sick in London. Referring to the provisions, state the matters in which the minutes are to be signed in the absence. It should be signed by the chairman. In case of general meeting, it should be signed by the chairman. In case of inability of the chairman to sign, it shall be signed by any person authorized by the board. So, shall be signed by any director who is authorized by the board. We've completed this. I hope it was of help. If it was of help, please leave a like and a comment so that we know it really helped you. Happy learning and stay motivated.